Criminal law. Non-fatal offences against the person. Battery. According to Section 39 of the Criminal Justice Act 1988, battery is a summary offence and has a maximum penalty of 6 months imprisonment. There is no statutory definition of the offence of battery. The definition and all elements of the offence are set out in case law. In R v Gladstone Williams 1984, the Lord Chief Justice, Lord Lane, defined the offence of battery as an act by which the defendant, intentionally or recklessly, applies unlawful force to the complainant. The actus reus of battery consists of 1. The application of 2. Unlawful. 3. Physical force. 1. Application. The application of force need not be direct. In DPPVK, A minor, 1990, the defendant was liable, even though he did not physically touch the victim himself. He had caused the application of force by putting acid in the hand dryer, that was then blown into the victim's face. Similarly, in Fagan v MPC, 1969, the defendant used the medium of a car rather than direct physical contact. 2. Unlawful. If the defendant has a lawful excuse to use force, the actions will not amount to a battery. Lawful excuse includes reasonable punishment of a child under Section 58 of the Children Act 2004, where the defendant uses reasonable force in self-defense or prevention of a crime under Section 3 of the Criminal Law Act 1967, or where the victim consents. In Attorney General Reference No. 6 of 1980, it was held that whilst a person could not generally consent to being injured or harmed, they could consent to an assault or battery. Consent may be express or implied consent. Lord Justice Goff in Collins v Wilcock, 1984, gave examples of implied consent as including jostling in crowded places and greetings such as handshakes and backslapping. In Donnelly v Jackman, 1970, tapping on the shoulder to gain attention was also given implied consent. In Marland v DPP 2023, it was held that there was no implied consent when the defendant grabbed his drunk girlfriend and led her towards his car against her will. He claimed he was trying to keep her safe. Whereas in Macmillan v CPS 2008, there was implied consent where a policeman grabbed a drunken woman to steady her and prevent her falling on some steps. 3. Physical force. Use of the term, physical force, is perhaps misleading in that it suggests a high level of force. However, any touching, no matter how slight, will suffice. In Faulkner v Talbot, 1981, the Lord Chief Justice, Lord Lane, defined unlawful physical force as any intentional or reckless touching of another person without the consent of that person and without lawful excuse. It need not necessarily be hostile, rude, or aggressive. The touching of clothing will suffice. In R v Thomas, the rubbing of a hem on a girl's skirt was sufficient. Lord Justice Ackner stated that touching clothing whilst a person was wearing them would amount to a battery. The mens rea of battery is intention to apply unlawful physical force or being reckless as to whether such force is applied. The case of R v Parmenter established that subjective Cunningham recklessness applies to non-fatal offences against the person. Therefore, the defendant must foresee a risk of application of unlawful physical force. In summary, battery is a summary offence with a maximum penalty of 6 months imprisonment. It is the intentional or reckless application of unlawful physical force, but will cover any touching without consent. The offence of battery doesn't involve an injury. If harm or injury is present, the crime could be either ABH, GBH, or wounding depending on the level of injury involved. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.